Hello everyone, welcome to yet another session of the daily news analysis by SRIRAM'S IAS, where we take up the important articles featuring in the Hindu newspaper and break them down for our understanding from the examination point of view. So let's start today's discussion by taking the important articles which are featuring in the newspaper. So let's take up our first article for the day. The first article which is appearing in the newspaper reads, "The hijab case and the essential practices doctrine." Now this particular editorial is occurring obviously, as we can see, in the context of the hijab case. Now what this case is, the matter is currently sub judice, which means that it is in front of the Supreme Court right now. So the matter started from a Karnataka High Court judgment which placed a ban on Muslim girls wearing hijab in schools, saying that this is particularly not an essential religious practice that the girls have to take forward, and a school is a public space, and therefore in that kind of a space such kind of practices cannot be termed as a essentially religious practice, and on that basis the Karnataka High Court upheld the ban, and now this case is in front of the Supreme Court, who will be dealing with this issue. So from this article, what is important for us is the essential concept of this essential practices doctrine. What exactly do we mean by essential practices doctrine, and how does every time in the issues where religion and society and other communities clash up, this doctrine is taken up by the court? So from the examination point of view, we'll try to understand about this doctrine as to what exactly is the essential practices doctrine. Now, what is this doctrine? The essential practices doctrine, it is a test which is being devised by the Supreme Court, evolved by the Supreme Court to protect only such religious practices under fundamental rights which are essential and integral to religion. Now, the basis or the genesis of this doctrine, the essential practices doctrine, the article suggests that it owes its existence to a speech made by B.R. Ambedkar in the Constituent Assembly. So he had first talked about this relationship of state, that is the government, with the religious practices of people in the society. Because when religion is so diverse for the people and it regulates more or less every aspect of an individual life, so how then can state intervene and intervene and make changes to these practices? So he gave out a philosophy in there. He said that the religious conceptions in this country are so vast that they cover every aspect of life from birth to death. That is correct. He said, I do not think it is possible to accept a position of that sort. So this obviously means that leaving out everything for religion to control is not a very favorable thing to do in a society which wants to regulate itself from a rule of law perspective and not a religious perspective. So he saw that since religion is regulating more or less every aspect of individual life, it cannot be let to regulate every aspect. So he said that such position cannot be accepted, and we ought to strive a hereafter to limit the definition of religion in such a manner that we shall not extend beyond beliefs and such rituals as may be connected with ceremonials which are essentially religious. It is not necessary that laws relating to tenancy or laws relating to succession should be governed by religion. So what do we gather from Ambedkar's philosophy over here? That first he identified that religion, whenever we talk about religion, it has the capacity to dictate for every aspect of human society. But if religion starts to dictate that, the rule of law society won't be able to accept that. So he tried to make a segregation, for there are some kind of practices in the religion which are necessary and which are connected to the ceremonials and rituals, so which become essential for the religion. Those can be kept separate and those can be left out of the regulation sphere for the government. But those aspects which are not necessarily connected to the basic tenets of the religion and are connecting to larger issues such as tenancy laws or laws relating to succession, which basically deal with society at large, they should be regulated by the government. These kind of aspects of the religion or the kind of religion connected to human society are known as secular matters of governance, wherein religion is involved but they are not necessarily connected to the essential practices. This became the basis of evolving the essential practices doctrine for the Supreme Court, wherein any case that which came into conflict with either the freedom of religion or state intervening into that aspect, this doctrine was used. So, this doctrine of essentiality was invented by a 7-judge bench of the Supreme Court in the Shirur Mutt case in 1954. This is when the first time Supreme Court came up with this doctrine. It then took the responsibility of determining the essential practices of a religion upon itself. This was from where the journey of essential practices doctrine in India started. And the Indian Constitution, under Article 25 to 28, we all know, guarantees the fundamental right to freedom of religion with some reasonable restriction. So, the Constitution of India does guarantee freedom of religion, and there are certain reasonable restrictions. And under these reasonable restrictions, the essential practices doctrine started to develop. And the Indian model of secularism also provides for states' intervention in religion to ensure freedom of religion. This is the basis for this doctrine. And when the exercise of religious practice came in conflict with other fundamental rights guaranteed under the Constitution, this doctrine of essentiality was utilized to decide on the constitutionality of such practices. So I hope the genesis, the significance and why this doctrine came up, we can understand right now. So has this doctrine been used in the past? There have been several cases where this doctrine have been used by the Supreme Court. So the major cases are the Sri Venkatramana Devaru versus State of Mysore case in 1958, where the Supreme Court had to decide whether restrictions on entry into temples for some sections was an essential part of the Hindu religion. Right? So this was the conflict that went into the court, wherein a section of people were not let to enter the temple, and the court had to decide whether this practice was an essential practice, and it held that such a practices are unconstitutional and void and opened the temples for all Hindus. Similar was the case of the Sabrimala, as we know. In the Sabrimala case, the Supreme Court had lifted the ban that prevented women and girls between the age of 10 and 50, mainly menstruating women, right? There was a reasonality given to this, wherein it had said that the deity had taken an oath of celibacy, and that is why it did not want women of this category entering into the temples. But this became a big issue, and eventually Supreme Court, using this doctrine, held that the women cannot be stopped to enter into the temple, and it allowed entry into the Sabrimala temple, and it held that the centuries old Hindu religious practice was unconstitutional as it violated Article 14. There was a heated debate on this issue that still is going on. The case is going to be heard by Supreme Court in the future, where both parties have their strong sides of argument, wherein one party said that this not letting women enter into the Sabrimala temple is an issue of violation of Article 14 and equality, whereas there were a side of people who also advocated that there are certain temples which also do not allow men into the temples, and it is the choice of the deity whether or not he wants to allow women or not. So these kind of reasons do exist, and both sides of argument are present over there. But our focus is exploring about this doctrine and what this doctrine is exactly, and how Supreme Court has been using it, and through it understand what are some of the good bits of the essential practices doctrine and what are some of the cons of this doctrine. This was also used in the famous Ayodhya Ram Janmabhoomi case, wherein the court held that offering prayers was an essential practice for Islam, but offering prayers in the mosque was not an essential practice. And on that basis, the verdict on the Ayodhya case was greatly influenced. So these are some of the examples where this doctrine was used. Now, what can be called that some of the benefits, or one can say that using this doctrine has some of the pros. So what can be some of the pros of this essential practices doctrine? First of all, it has ensured balance between fundamental rights, right? All kinds of fundamental rights, be that freedom of practicing religion, other right to equality and other rights. It has sought to cite a balance between these rights. For example, in Sabrimala case, it attempted to strike a balance between the two fundamental rights of right to equality and right to freedom of religion. Then it ensures social justice during the practice of right to freedom of religion. So as we saw in Ambedkar's speech, that he saw that there can be some practices which can be taken out of the religion and it might necessarily be causing harm to some sections of the people. Therefore, this doctrine can be used to ensure social justice as well. It ensured that constitutional morality was given primacy over religious morality. This can be said as a benefit of the essential practices doctrine, which said that the matters of the land would be ruled by principles of law and not by tenets of religion. So it gave primacy to constitutional morality. And to give freedom to people in a multicultural society, Supreme Court struck down section 377 as well. This was also an example, right? Then it ensured that there will be primacy of rule of law rather than rule of religion, right? This is what we saw. And lastly, the doctrine protects the essential practices of religion from interference of the state. So at one part where the state is intervening for secular matters or those are not essentially connected to religion, at the same time it is also protecting those practices which are essential to the religion. So this is also a kind of benefit that it grants protection to the essential practices. So these things can be called as the benefits or pros of this essential practices doctrine. But are there some challenges? Are there some cons in this? There are certain issues as well. A major issue is that what constitutes an essential practices shall be decided by the judges or members of the community. Here is where the fundamental question comes in, wherein when one goes to regulate or draw a thin line between what is an essential practice to religion or what is not, it will always become a very tricky matter of adjudging or gauging which is that practice which is essential or not. And who is going to do this? If judges of the court are going to do this, their education in law and all the education they have had until now is mostly based in legal matters, and now deciding on this is going to require them to become theological experts or priests or other religious experts. And are they those kind of experts? They hardly are. That is why the inclusion or the role of judges in deciding which practice is an essential practice or not is a major problem and is a major question with this doctrine. Therefore, this is a major question as to who is to decide which is the essential practice. Then there is no fixed parameter for deciding the essential practices. So at one point, some practice might look like an essential practice, and in some other aspect, some practice might not look like one. So in some cases, they have relied on religious texts to determine essentiality, in others on the empirical behavior of followers, and in yet others based on whether the practice existed at the time the religion originated or not. So the lack of fixed parameters present to decide which practice is an essential practice is also a major problem, and because of no fixed parameters, there comes a space for larger discretion. And whenever there would be discretion, there can be a case of favoring one community or favoring one practice from the other, causing discomfort or displeasure in the other section which is facing the problem. So that becomes a major drawback of this kind of a practice. So it does have its intent in the right place, but there are certain pitfalls. And then the constitutional law experts have argued that the essentiality or the integrality doctrine led the court into an area that is beyond its competence. Like we saw, they are not experts in the theological studies or religious matters, and given judges the power to decide purely religious questions. So these are some of the fundamental problems which are existing with the essential practices doctrine. So now what? Because the intersection of religion and society and law will always happen, and the question over which practice should be allowed or not on the pretext of religion will always hold a question in front of the court and in the society. So what can be the way forward that can be suggested in this? The way forward, as it comes out in the article, comes from the opinion of Justice D.Y. Chandrachud. He is an existing Supreme Court Justice, and in his opinion, in the Sabrimala case, the author tries to gather a way forward. And what is that? It's a alternate solution or alternate doctrine known as the principle of anti-exclusion. What is this principle of anti-exclusion? So, according to Justice D.Y. Chandrachud, its application would require the court to presume that a practice asserted by a religious group is in fact essential to the proponents of its faith. So, the doctrine says that the first assumption that the doctrine would make is that every practice is an essential practice for the religion. But regardless of such grounding, the constitution will not offer protection to the practice if it excludes people on the ground of caste, gender or other discriminatory criteria. So he tries to narrow down on the principle and fix a parameter, as we saw the challenge for the essential practices doctrine. So what he tried to do was fix a parameter for it, wherein if any practice basically results into discrimination on the basis of caste, gender or other criteria and excludes a certain category of people, on that basis that practice can be set out, and this is what he named as the principle of anti-exclusion, wherein every practice that exists in the religion should be necessary, but where it starts to exclude people and starts to discriminate, there is where the court will intervene and that can be struck down. He put it that the anti-exclusion principle allows for due deference to the ability of a religion to determine its own religious tenets. It gives it the freedom and doctrines. At the same time, the principle postulates that where a religious practice causes the exclusion of individuals in a manner which impairs their dignity or hampers their access to basic goods, the freedom of religion must give way to overarching values of a liberal constitution. This is where he took the balance and gave the precedence to the liberal values of a constitution, wherein such cases which started to discriminate between people, right? So this was the way forward that is suggested by D.Y. Chandrachud, which we can make use of whenever we encounter a question on the discussion of this essential practices doctrine. So I hope this is clear. We saw the genesis of the doctrine, how it came by, what was its principle, what are some of its examples, what are some of the benefits, its challenges, and what can be the way forward. So with this, let's move on to our next article for the day. The next article which appears in the newspaper reads, Oil Ministry seeks review of windfall tax and wants certain fields exempted. Now, this particular article throws light on this important concept of tax known as windfall tax. Now, what is this windfall tax? This windfall tax is a very newly instituted tax, hardly 2.5 months old, when the COVID pandemic descended and the Russia-Ukraine war started and the fluctuating prices of oil the fluctuation started to happen. This is when the governments started to levy a certain kind of tax on oil companies and other companies known as windfall tax. Now, what is this windfall tax? We'll try to understand that, and why is an ministry of the government itself asking for a review of this tax, right? So let's understand from the examination perspective, what is this windfall tax? What is its rationale? Again, what are some of its good points and its challenges, and why is the ministry asking for a review of this tax? So what is windfall tax? These windfall taxes are designed to tax the profits of a company which derives from an external, sometimes unprecedented event, for instance, the energy price rise as a result of the Russia-Ukraine conflict. So windfall taxes are those specialized taxes in specialized events, wherein some due to unforeseen events or events which are not in the hands of the companies, and due to those events these companies start to earn extra profits, and since they are earning extra profits, the government feels like charging extra taxes from them on their extra profits, and this extra amount of tax is nothing but windfall tax. These profits that cannot be attributed to something the firm actively did, like an investment strategy or an expansion of business, and is purely based on a coincidence or an external event, that is when the need for a windfall tax is arising. And this is defined as an unearned, unanticipated gain in income through no additional effort or expense. So the rationale that is used by the government for levying an extra tax is that the firm or the main people of the firm did not do anything to increase that profit, and it is simply based on externality event, and that is why it feels that such extra charges can be levied. So governments typically levy a one-off tax retrospectively over and above the normal rates of tax on such profits called the windfall tax. And one area where such taxes have routinely been discussed is the oil markets. So recently, government increased its windfall tax on these oil companies because they were able to get increased profits because the price of Russian oil became very cheap for them and they were able to procure Russian oil for cheap prices, right? So what can be the rationale for this? The rationale given by the government is that there have been varying rationales for governments worldwide to introduce windfall taxes, from redistribution of unexpected gains when high prices benefit producers at the expense of consumers. So basic rationale is always by the government side is that since you are earning extra profit by no extra effort of yours, this profit can be given to the government, which will then use it for redistribution of this income and ultimately benefit the economy, to fund social welfare schemes and as a supplementary revenue stream for the government. This is the rationale that is given by the government to charge such a tax which is over and above the income, which is for the extra income earned by the firm. So it's not just India, but other countries such as UK and other such countries are also levying windfall tax on their companies. So why are countries levying windfall taxes now? So as I gave you the reason about the fluctuating oil prices due to the Russia-Ukraine war has become the major reason for countries levying windfall taxes. So prices of oil, gas and coal have seen a sharp increase since the last year in the first 2 quarters of the current year, although they have reduced recently, right, due to the Russian oil prices have decreased. And the increase stems from a combination of factors, including a mismatch between energy demand and supply during the COVID-19 pandemic and further amplified by the Russian war in Ukraine. And this pandemic recovery and supply issues resulting from the Russia-Ukraine conflict show up energy demands, in turn driving up global prices. This is the reason why many countries are levying windfall taxes on their oil companies. Then the rising prices meant huge and record profits for energy companies while resulting in hefty gas and electricity bills for household bills in major and smaller economies. So the brunt of these prices were faced by whom? The households which are using this electricity. And in order to again redistribute this income, this windfall tax was initiated by the government, and the levies came as refiners made major gains by boosting fuel exports to countries that were in a deficit like Europe, which has now boycotted oil imports from Russia. And the UN chief urged all governments to tax these excessive profits and use the funds to support most vulnerable people through these difficult times, right? So the rationale for this was also supported by the UN chief, and the calls to introduce windfall taxes also found support in organizations like the IMF, which released an advice note as to how such a tax should be levied. So these are the reasons given for various countries that have started to levy windfall tax now. So what can be the benefits of the windfall tax we saw? What are some of the issues now with respect to levying a windfall tax? The first issue is that there is uncertainty in the market, which means that companies are confident in investing in a sector if there is certainty and stability in a tax regime. This is a true fact, wherein if companies know about their tax slabs, they are more confident in investing in the economies. But if they do not know, and at any time, and which is based on their share of profits, if the share of taxes can be increased by the government, it creates a situation of uncertainty in the market, which is never good for increasing the investment. And such taxes are imposed retrospectively and are often influenced by unexpected events. They can brew uncertainty in the market about the future. Then they are also populist in nature. What do you mean by populist in nature? By saying that windfall taxes are populist in nature is said that the rationale for them is said to be benefiting the public at large, and that is why such taxes are also termed as populist or politically motivated. Then such kind of taxes also reduce future investment, since it creates uncertainty in the market and companies are discouraged from carrying on their business. It basically reduces future investment, and the major problem also is that it is not defined precisely as to which companies under which tax slabs would be levied with the windfall tax. That has not been defined precisely, which also again creates confusion in the minds of the companies. So these are some of the issues which are involved with the levying of windfall tax. Now coming to the article, why is the oil ministry asking for a review of this windfall tax? So it feels that the kind of excess tax on the profit that the government is levying, these kind of conditions already exist with respect to the pre-existing law provisions of the government for oil taxes, and there is no need for a windfall tax, is the reason that the oil ministry has submitted to the government and asked to review and cut down on the windfall tax. Now it remains to be seen what happens with that development. So we finish our discussion over here, and we finish the important articles from the day as well, and we'll meet again tomorrow with the important articles from the day. Thank you.